Sam Seder on the Majority Report. I am in Las Vegas at the Mass Torts Conference 2024 in the Bellagio Hotel. I'm sitting now with attorney Jeff Gaddy. He is from Levin Papantonio firm. And Jeff, thanks for joining us.
Absolutely.
About a week or two ago, there was a big case dealing with TikTok. It involved a lawsuit from parents whose child, I think she was like 11 or 14. I can't remember the age. Mm-hmm. She had seen this sort of like TikTok meme or thing that had been going around about essentially suffocating yourself. And she did it. She died. And I think for what constitutes the first time, and you correct me if I'm wrong, a social media company was responsible for something that they didn't post, right? They just allowed it to be posted. Mm-hmm. Despite the fact that Section 230 exists, which ostensibly shields them from liability for what users produce. Tell me your thoughts on that case, but first let's start with the case that you're involved in this multi-district litigation.
Sure. So my firm represents hundreds of individuals who have been harmed by their addiction to social media and by these social media platforms, whether it's Meta, which obviously owns Facebook and Instagram, Snap, which owns Snapchat, Google, which owns YouTube, or ByteDance, which is TikTok. All of these companies have designed their platforms in a way to be addictive and to maximize the amount of time that children spend on these platforms. And unfortunately, just like our politicians, some of them at least, they've realized that divisive content and harmful content drives engagement. And that's what these companies have been pushing. The case you reference is what we call challenge material. We often see it on these social media platforms, and we found that some of these social media platforms push challenges as part of their brand because they know it drives engagement, and they know that children react to that, and they like the feedback loop, and they like the engagement that they get from that. And so I think we are seeing a turning of the tide. You're right that these platforms have always pointed to Section 230 and said that gives them blanket immunity. No more. Courts around the country are making clear that they are being held responsible for the design and the development of their platform, not the content. And it's the design and the development of their platforms and the way that they write and create their algorithms to push this harmful content, this harmful addictive content to children, is what they're being held accountable for.
So there really is almost like two tracks in which these social media outlets are being held responsible. One is that's sort of like almost a direct assault on Section 230. And it sounds like your multi-district litigation sort of slides alongside of Section 230 and says, okay, you can say that you are not held liable for the specifics of the content, but you're talking about the delivery mechanism, which is their product, right? I mean, this sounds more like a product liability case on some level.
Yeah, in a lot of ways it is. It exactly is. And it's a failure to warn case because these companies know what they're doing. What I think is one of the most compelling aspects about this litigation is it's not a bunch of lawyers saying that they did bad things and that it's causing bad problems. These companies studied it themselves. The whistleblower from Meta came out with the document showing that Meta had done their own studies and that Instagram was harming young girls in particular, and that up to 17% of girls were developing worsening eating disorders after spending time on Instagram. Up to a third of girls were feeling worse about the way their bodies looked after being on Instagram. And what they did was take that report and put it in a drawer, and they didn't react to it. And so I think it's compelling that it's these companies' own studies, their own data, their own analysis that's led them to these conclusions. And instead of fixing the problem, they've made it worse, and they've exacerbated it by continuing to allow this addictive, harmful content get out. Because look, their business model is engagement. I mean, these companies primarily make their money off of advertising revenue, and they know that therefore they're incentivized to keep eyes on the product as long as possible.
What's fascinating to me about this, and it came up in that TikTok case, which I know is sort of like a slightly different, but not necessarily, right? I mean, because that TikTok case was about how their product was serving up dangerous material, essentially, in these challenge cases. But the court in that case found that because the Supreme Court had found in a separate case about censorship, where a couple of states wanted to sort of inhibit, I think it was Twitter or TikTok's ability to present or to censor, I guess, so-called misinformation, the Supreme Court said that would be infringement upon speech. Then the lower court said, well, okay, now that we've established that what these social media platforms do is their own speech, suddenly then they don't get liability protection from 230, which is supposedly protects them from liability from other people's speech that just shows up on their platform. So they get sort of jammed in there, didn't they?
You're exactly right. So there's really three buckets here, right? There's true third-party content, which is what Section 230 speaks to. Then you have the platform's own independent content. They have no protection from that under Section 230. Section 230 does not immunize them whatsoever from their own content that they push out to children. And then the third bucket would be the design and development of their own platforms. What we saw the court do in the multi-district litigation out in Oakland, California, was do a feature-by-feature analysis of these different platforms and look at the different components of these platforms and decide, does 230 protect certain features? And for example, one is age verification. None of these companies require parental consent until they allow children to sign up on the platforms. Every one of these companies has the ability to do a better job of making sure that children are not getting on their platforms. As I've mentioned earlier, it's not just us saying this. Some of these companies did their own studies and realized that there are scores of children under the age of 13 on these platforms when they're not supposed to be under the own terms of services of these platforms. But yet they allow it because, again, eyes on the platform is what drives the revenue for them. And so you're right. There's three buckets, and it's the addictive design that's pushing this harmful content that's really moving the needle. Let me give you one more example. It's a case going on in Georgia right now against Snapchat. And what's at issue there is a feature that Snapchat used to have called the speed filter. I don't know if you've heard about this.
No.
This is where children could ride around in a car, and it would tell them the speed that they were going, and it would broadcast it out to all of their friends.
Oh, geez.
And so, as you can imagine, what that led to was children getting in the car and trying to hit 100, 110, 120 miles per hour. And sure enough, in one tragic incident in Georgia, some boys were doing that, and they crashed into another car, caused traumatic brain injury, put somebody into intensive care. And that case is moving along. And Snapchat tried to have that thrown out under Section 230 and saying, hey, that's that independent content of this third party that's broadcasting what they're doing. And the court there says, no, this is the feature of your platform that you made available that caused this harm.
So I'm curious about bucket number two, right? Because bucket number one, like, and it's easiest for me, as an old person to contemplate this in the context of blogs, right? Because back in the old days, I'd write a blog post, let's say, and I could say something. I'm liable for that. But then we have comments, and the comments get stacked up. They're just one after another. There's no other sort of like bells or whistles about it. I'm not responsible for what people say in the comments. But social media then has like these algorithms that feed, like, highlight certain comments, fill your feed with it, et cetera, et cetera. Those are the sort of like the structure of what they're doing. And they know why they're doing this. They have that research. The middle thing where like the content that they create, like how do we define that? Because if we have like if I put a border around one of the blog comments to highlight it, I don't change what's in there. Someone else put it up there, but I put a border around it to emphasize it. Am I now responsible for that content because I have created a derivative product out of it in some way?
Look, I think arguably so, because you've now done something to augment something that was there by a third party, and you've highlighted and emphasized it. Look, when I've started digging into the Section 230 stuff, a couple of statistics really jumped out at me. As you know, this law became law in 1996.
Yep.
When
the
they were
Telecommunications Act.
Yeah. When the Communication Decency Act, when they were debating and drafting this law in 1995, over half of the U.S. senators didn't have internet connection. Only a quarter.
Well, then, if I recall correctly, it was just a series of tubes.
Yeah, exactly right. The information superhighway, correct? So yeah, only a quarter of the House of Representatives had email accounts. So you had a bunch of guys, mostly guys, and some women who were drafting this law who hadn't even heard the ubiquitous "You've Got Mail" before, and obviously Congress had no idea about the advent of the internet and the algorithms that would be pushing this content to children these days. And so you're right. You really have to get into the weeds and examine each of these different features and components of these platforms on a feature by feature basis, and see whether or not what we're talking about falls into one of those three buckets. And if it's true third-party content, that's not what the lawsuits are about. It's about the design and the development of these addictive platforms that are pushing this harmful content to children.
And we should be clear that at the end of the day, all of this is about making money in profit for these companies, right? I mean, because that's the reason why they have these algorithms.
Mm-hmm.
It increases their profit margin. Now, of course, they could also be hiring an army of people to sort of moderate this stuff and to sort of like check and see if it's problematic. But in some instances, they already know it's problematic, and they don't want to have a sort of trail of evidence that they knew it was problematic.
100%.
And they want to save on labor costs too. So it's sort of a win-win for them and a lose-lose for everybody else.
Yeah, it really is. And again, this is stuff that the whistleblower who came out years ago, it made this very clear that these companies know that if they make these corrections that we're demanding they make, it's going to drive down engagement. And if you drive down engagement, you drive down revenue. And that is, it's not their business model. And so until we continue to pursue these cases and continue to hold them accountable, I think that's the only way we're going to see real change. We can all sit back and continue to hope that Congress will act, but we all know how that's gone for the last several years. While we've seen hearing after hearing, a dramatic hearing several months ago when Mark Zuckerberg turned around and apologized to a group of parents that were there in the galley who had lost children to social media addiction and self-harm. And we've seen dramatic moments in Congress, but we haven't seen results yet. So we think civil litigation is the way to hold these companies accountable.
Is there, are we sort of like, it feels like there's almost like a game of chicken that's going on between those who want to hold these social media companies accountable and the social media's claims of like, we don't want to be censored, because you can't say we're being censored if you're also claiming we're also not publishing anything, right? Like censorship is not about like you can't make that claim that your First Amendment rights are being infringed if you're also claiming that it's not my speech.
Yeah, and look, what makes it a game changer to me is our litigation. We're talking about children,
right?
What we're not talking about folks like you and I. We're talking about children who have undeveloped brains and who are being pushed this content by the very most sophisticated software developers in the world, who are trained to get them addicted to these products and keep them addicted to these products and keep them online. And so that's when you talk about the game of chicken and the different competing interests. And to me, when you're talking about children, all that other stuff just goes out the window, and we got to make some changes.
Yes. And I guess this may be outside of like your portfolio, as it were, at this point, because you're working on this specific case, but I can't help but hear echoes of where we went with tobacco litigation, which of course, the Levin firm was integral part of. But we didn't sell tobacco to kids under the age of 18. We had restrictions on that, and then ultimately, I mean, decades later, we understood that for the same reason why we had to protect kids, ultimately we had to sort of like protect broader society. I know that's not the intention of this suit, and it's, outside of the scope of your servicing your clients. But in some way, like, do you have a sense of where ultimately change is coming, like with a broader understanding of this? Social media is, can be problematic too. And people like to have a drink, but it also can be problematic down the road. We have restrictions on it.
Totally understand. The first thing I'll say is, look, our clients want to see change too. So do they want to be treated fairly for the harm that's been caused to them? Of course, but they want to see change also. I'll give you a couple of comparisons. You're right. When the attorneys generals filed their case last year against Meta, just this week, they filed about 17 of the attorneys generals filed against TikTok, similar claims. I wouldn't be surprised to see more suits in the coming weeks or months against some of the other platforms. When they announced those lawsuits, they likened these cases to tobacco and also to opioids that we've seen devastate the lives of so many people. The industry that I think big tech is most similarly situated to right now is the pharmacy benefit managers, who I know you've talked about before on the show, and some of the basically acting as the middleman, and everybody's trying to looking around, figuring out what do these guys really do, and what do they really add to the equation here. And there's litigation over insulin price fixing and those types of things that, and there's also bipartisan agreement that something needs to be done about both the big tech industry and the PBM industry. So I kind of, those are a couple of comparisons that jump out to me when I look at these industries. And so look, like I said, we hope that Congress will act. We hope that these companies will take some accountability and make some changes on their own. But until they get it right, we're going to keep pressing on.
Taking even a step further back, because I know you have colleagues who are working on the insulin price fixing and the PBMs, the pharmacy benefit managers are, and they're complaining about it. They're under assault really from sort of like both the civil litigation front, or the private, I guess, litigation front from plaintiffs' attorneys in regards to like price fixing and other matters. And on the other side, like the FTC and Lena Khan and the DOJ is starting to look around, and everybody's asking like, wait a second.
Well, what happened is they figured out the emperor has no clothes, and they've been exposed, and that's why it's continuing the way it is.
What's the role of plaintiff attorney in this, right? Because, I have always, in the years I've been coming here and interviewing, trial lawyers, I've likened it almost to like, when in the old Western movies where the sheriff says like, I need some deputies. I'm going to deputize this posse and go out and do it. And this augments the lack of infrastructure sometimes by government regulatory agencies or attorney generals, either state or federal. And how much does like the work that you guys do, this is a more broad question than just the social media, end up providing sort of like both stuff from discovery, I guess, but also just more broadly in terms of like a new understanding of what's going on within an industry that ends up leading to statutory changes that in some way, sort of you catch in the car on some level, but for the betterment of society.
Yeah, I mean, to pick up on what you just said, I mean, about a vehicle, I mean, one of the reasons there's seatbelts in cars. Government is not efficient and does not act quickly. And I was very involved in the opioid litigation. And the first day we were in court, Judge Polster, who ran that case, commented that this is a problem that should be solved by the legislature and should be solved by the executive branch, but they failed. And so the judiciary now had to get involved. And we did that and had the ability to hold these companies accountable because their lobbying dollars don't work on us. And so we're able to go toe to toe with these companies and bring about real change. And we're very proud of the fact that in opiates, we've recovered over $60 billion for states and local governments across the country to help address the harm from opiates. But on top of that, there's been real injunctive change too. These companies have had to change the way they do business. They've had to stop marketing directly to consumers for opioids. They've had to correct some of the misstatements that they'd made previously about what they claimed was the non-addictive nature of these drugs. So yes, the civil justice is something that we pursue daily, and that we're very proud of the impact that we've made on society and will continue to make when we take on these big issues.
What are the damages that in your social media case? What are the damages that your plaintiffs are seeking, and like what and how does it work? Like the idea with a mass tort as opposed to a class action is that the defendant has taken certain actions that has had disparate impact on the plaintiffs. Is that it?
Right. Yeah, it's very different than a class action. Class action, I always kind of liken to getting a cable bill that's got a bogus $12 charge on it every month. And so everybody's got the same bad action. Everybody's got the same damages. As you said, in the mass tort world, same bad conduct, but it impacts different people in different ways. There's two types of plaintiffs in these cases. One are the individuals plaintiffs who are receiving treatment. Whether it's physical treatment, some of these children unfortunately have harmed themselves. The most tragic cases, children have taken their own lives. We have children who have developed eating disorders based on their addiction to these social media platforms and the way those platforms were designed to push anorexic and bulimic type content towards them. And so those are the types of damages that we'll be pursuing in those cases to make them whole, to pay for the treatment they've had to receive and make them whole after this harm that's happened to them. The other group of plaintiffs are school districts who have had to take on the expense of bringing on additional resources to deal with the harms that come into our schools from social media, from the TikTok dances that happen in the bathroom mirror, to adding counselors and the like, to deal with the additional trauma that some of these children are experiencing. And so that's how we're going about it. In those cases, we're looking to recover dollars for the school districts because they shouldn't be the ones paying to clean up for this mess that these companies have caused. And that's where we're headed.
Jeff Gaddy, thanks so much for your time today, Levin Papantonio, and we'll be following this and see you hopefully maybe in April and get a sense of where these cases are progressing to. And I imagine there'll be more plaintiffs added as the awareness of these cases grow.
Yeah, there's more cases being filed every day.
Thanks so much for your time today. I really appreciate it.
Thank you.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.